Welcome to the Supreme Court of the United Kingdom. This is the summary of the Supreme Court's judgment in Crown on the application of Highbury Poultry Farm Produce Limited against Crown Prosecution Service. The appellant in this case is Highbury Poultry Farm Produce Limited. I shall refer to it as Highbury Poultry, which operates a poultry slaughterhouse. The average throughput is 75,000 chickens per annum, equating to 19.5 million or so chickens per annum. 75,000 chickens per day, equating to 19.5 million or so chickens per annum. The birds have their legs shackled to a moving line and are then submitted to a number of sequential processes, including stunning, bleeding, and scalding. On 3 separate dates in 2016, a chicken went into the scalding tank where its feathers would be removed while still alive, because after stunning, its neck had not been properly cut. Highbury Poultry was charged with 2 criminal offences under Section 31G of the Welfare of Animals at the Time of Killing England Regulations 2015. in respect of each of those 3 incidents. The question for the Supreme Court was whether those offences under Section 31G require the prosecution to prove that Highbury Poultry was negligent, or whether these offences impose what the law calls strict liability, where the defendant is guilty in relation to the conduct in question, even though negligence cannot be proved by the prosecution. The first instance judge, District Judge Cadbury, sitting in the Magistrates' Court, held that they were offences of strict liability. Highbury Poultry unsuccessfully challenged that ruling before the Divisional Court in judicial review proceedings, and Highbury Poultry now appeals to the Supreme Court against that decision of the Divisional Court, dismissing its application for judicial review. The Supreme Court unanimously dismisses the appeal of Highbury Poultry. The judgment is given by myself, with whom Lord Reid, Lord Lloyd-Jones, Lord Kitchen and Lord Hamblin agree. In determining that the offences are ones of strict liability, a number of interesting legal issues arise. In particular, the English regulations implement an EU regulation, number 1099 of 2009, on the protection of animals at the time of killing. It follows that the correct principles of legislative interpretation to apply are those of European Union law. If the EU regulation imposes strict liability, the domestic regulation must, as a matter of EU law, do the same. And certainly without a clear indication in the domestic regulation that the EU regulation is being departed from, the best interpretation of the domestic legislation must be that it is merely the mechanism for implementing what has been laid down by the EU regulation. Indeed, applying the so-called mar-leasing principle, even if there are words in a domestic regulation that on their face depart from what an EU regulation requires, the courts of a member state are required, if at all possible, to interpret the words of the domestic regulation so as to conform with the EU regulation. In any event, in this case, the words of the domestic regulation make clear that it is implementing whatever standards are imposed by the EU regulation. And I interject here that under the Brexit arrangements, until the end of this year, 2020, there is no change in the application of EU law in the United Kingdom. So the Supreme Court is required to interpret the EU regulation and hence the English domestic regulations by applying EU law principles of legislative interpretation. What is commonly referred to as the teleological approach to legislative interpretation, adopted by the European Court of Justice and the Court of Justice of the European Union must therefore be applied, which means that there is a heavy stress on seeking to ensure that the interpretation of the words fulfills the purpose of the legislative provision and, more generally, the purposes of the European Union. It's also important to appreciate that just as one can have strict liability in domestic criminal law, despite there being a presumption that a crime requires mens rea or culpability, so the imposition of strict liability in the context of criminal law is not contrary to EU law. Looking closely at the words used in the EU regulation, in their context, and especially in the light of the purpose of the regulation, it is the view of the Supreme Court that applying EU law principles of legislative interpretation, both the offences in question are correctly interpreted as imposing strict liability. There is no requirement to prove negligence. Although our reasoning differs in some respects from that of the Divisional Court, the appeal of Highbury Poultry is therefore dismissed. The criminal case should now proceed before District Judge Cadbury to be finally determined on the basis of whatever further evidence the parties wish to adduce.